My name is Kevin Adams. I'm an Oklahoma criminal defense attorney, and I wanted to take a moment today to talk to you about probable cause. Now, probable cause is one of the most important concepts in our criminal justice system. And in fact, I would say that much of the confusion and the frustration that people experience in not understanding what's going on in the criminal justice system could be traced back to a lack of understanding of probable cause and the importance that probable cause plays in our system. Now, courts have pretty much universally defined probable cause as enough evidence to make a reasonable person believe that a crime was probably committed and that the defendant committed the crime. Now, when an officer arrests somebody without a warrant, okay, it's a probable cause arrest, okay? So like if an officer pulls somebody over on a traffic stop, they walk up to the car, roll down the window, there's an overwhelming smell of alcohol, an overwhelming smell of marijuana, that is probable cause, okay, that a crime was committed and that the defendant committed the crime, okay? If officers show up at a home and on a domestic violence call, they hear screaming, things being broken, they open the door and one of the residents has a black eye or bloody nose or busted lip, okay, that's probable cause, okay, that a crime was committed. Not enough to convict somebody, it's far from enough to convict somebody, but it's certainly enough to get the process started. Okay. When an officer takes an affidavit for a search warrant to a judge and asks the judge to issue a search warrant, the judge is reviewing that affidavit to make a determination of whether or not there's probable cause that there's evidence of a crime there, probable cause whether there's going to be evidence of a crime located at the place that's to be searched. After somebody's arrested on probable cause, the officer fills out an arrest and booking sheet. When the person gets booked into jail, that's what they give the jail. This is why you're holding this person. It's called an A and B. And they have to have that so they know why they're holding on to the person. And a judge, even though the defendant doesn't see it, a judge will review that within a certain period of time and make a determination of whether or not they believe, based upon what's stated, that probable cause exists. If not, the defendant should be released from jail. When a prosecutor brings an arrest warrant for a defendant, and they're starting the process by filing formal charges, okay? The prosecutor has an affidavit associated with that, and the judge is reviewing the affidavit to make sure that the judge believes, in the judge's opinion, that in fact there is probable cause that a crime was committed. Once the process starts, if you're charged with a felony in Oklahoma, then you have an Oklahoma constitutional right to a preliminary hearing. The purpose of the preliminary hearing is to make a determination of whether or not probable cause exists that a crime was committed and probable cause that a defendant committed the crime. The difference between a preliminary hearing and all the other determinations of probable cause is this. At the preliminary hearing, the defendant is represented by counsel. And so it's an adversarial probable cause hearing. And the evidence that's introduced should meet the standards as described in the rules of evidence, okay? The applicable rules of evidence. And it's a different rules of evidence for a preliminary hearing than it is for a trial. Primarily, you do not have as strong of a right to confront the witnesses against you at a preliminary hearing as you do at trial. Because the right to confront, the Sixth Amendment right to confront, or the Oklahoma constitutional equivalent, is in fact a trial right. So you see these people on TV, these talking heads talking, and that's all they're doing is just talking about in our system, it's based upon a presumption of innocence, okay? Yes, at trial, it's based upon a presumption of innocence. Our system is not based upon a presumption of innocence before trial, okay? Before trial, what drives the criminal justice system is probable cause. Now, I disagree with the determination and the way that the judges in Oklahoma and perhaps other places make a determination of probable cause. And here's my complaint with it. The complaint is that at a preliminary hearing, the judges in Oklahoma will not make credibility decisions, okay? And they say credibility decisions are reserved for a jury. Well, I understand that. It's actually, I understand what they're saying, but I disagree with it. Credibility decisions are reserved for a finder of fact. And at the preliminary hearing, the judge is the finder of fact. And if you're not willing to make credibility decisions, then you can't have a reasonable man or a reasonable person standard, okay? Because if you have a reasonable person standard, it's implied that a reasonable person would actually believe what it is that this witness is testifying to. Now, the judges that are making these determinations are following the law, okay? The case law that has been passed down, you know, over the years and stuff, and that's what the case law says. But from my standpoint, from where I'm looking at it, I think the case law is wrong and should be changed. It could be changed by the legislature, but it's just not. If we were to do this, we would weed out a lot of cases that shouldn't. Because once that probable cause determination is made at a preliminary hearing, the defendant is bound over for trial. And if you can't get that reversed, okay, then the defendant is going to have to make a decision of whether or not they want to risk their freedom in order to exercise their right for trial. And that's the thing that people misunderstand, okay? You're only presumed innocent at trial with probable cause, with bail determination, all these other steps along the way. It's presumed that the state's case is going to get stronger. It's presumed that what the state is alleging is true, and the courts will not make credibility decisions, okay? Now, this isn't such a problem if you have prosecutors that are experienced and that are reasonable, okay? But where you really have the problem is if you have overzealous prosecutors that are inexperienced, that are not being reasonable, that may be motivated by something other than whether they can prove the facts of that case, like if they think the defendant is a bad guy that they need to do something about, then that's where you kind of get the perversion going in our system. But probable cause is one of the, if not the most important concept to understand to truly have an idea of what's going on in our criminal justice system and why the judges are making the determinations that they are, and why a lawyer may be advising you the way that they are. Because it doesn't matter whether or not you can win the case at a trial if taking the risk of trying the case is not worth it. And most cases aren't resolved because of guilt or innocence. Most cases are resolved because of a calculation of risk. Anyway, I hope this has helped you understand a little bit about our criminal justice system and give you a little clarity of why things are going on. And I hope it helps you make better decisions if you're facing criminal charges yourself. If you would like to learn more about the Oklahoma criminal justice system, you can check out my website, oklahomacriminallaw.com. And once again, my name is Kevin Adams.